I'm attorney Phil Jusino, and this is Finding Common Ground here on Altice. You can catch Finding Common Ground on Saturdays at 10 a.m., channel 115, and also on Thursday morning, 1 a.m. on channel 20. Got a great show planned for tonight. Before we get to that, I also do a thing called Frequently Asked Questions on the second segment of this show, but I also do it on YouTube. You can catch that by going to Jusino Law, and I have Frequently Asked Questions ranging from topics such as criminal, matrimonial, family court, personal injury, and wills and estates. That's Jusino Law on YouTube. Also, WLINY Internet Radio on YouTube. You can catch all these shows. So if you miss one of these, Finding Common Ground on Altice, all you got to do is go to YouTube. WLINY Internet Radio is a catalog of all the shows. We have 3 segments planned for tonight. The first segment is a half hour, and that covers eyewitness identification, not very reliable. You'll see how faulty it can be. And in fact, we're going to use an example of a man that was charged with murder in Los Angeles, and believe it or not, Larry David of Curb Your Enthusiasm, also Seinfeld fame, helped save that man, spring him from the death penalty. The second topic will be frequently asked law questions, as I touched on a little while ago, where I ask a question, or I say a question that has been asked of me, and I give an answer. And the last segment is called American Exceptionalism. I cover a great American. It could be a natural-born American. It could be somebody that came here from another country. They're American. I've done it on Lincoln. I've done it on George Washington. This one is about Levi Strauss. So let's get to it. The first segment is witness identification. And I said a little while ago it can be very, very faulty. People think, oh, I made an eyewitness identification. That's great evidence. And juries sometimes gobble that up, because a guy could say, that's the guy that I saw running from the scene, and the jury is going to say, the guy's not lying, he has no motive to lie, and he's probably right. And many, many people are convicted of eyewitness testimony. Sometimes the witnesses are right, sometimes they're wrong. And fortunately, in certain cases, not all, we have DNA, which didn't exist, let's say, in the 70s and even into the 80s. But now with DNA, people can be freed. There's a thing called the Innocence Project. And with new technologies, in fact, there's technologies that haven't even come out yet that may spring somebody down the road, where let's say there wasn't enough of a sample for DNA. But down the road, there'll be all kinds of technologies that can free people that are doing hard time. The first example is a case involving a man named Juan Catalan. He was about 23 at the time. This goes back to 2004. And there's a documentary on Netflix. If you have Netflix, look up Long Shot. Not Long Shots, that's a football movie, Long Shot. And it's not the greatest of documentaries. It looks like it's done hastily, but it's fascinating. And it talks about a man, Juan Catalan, who finds himself in a courtroom with his brother who's charged with murder. He's not charged with anything at that time. And a 16-year-old girl who's a witness to that murder. Shortly thereafter, the 16-year-old girl is shot to death right outside her house. And somebody looking at a sketch of the culprit picks out Juan Catalan. He's arrested and charged with murder. First, he's given a legal aid attorney, and it looks pretty bleak. The assigned prosecutor is nicknamed the Sniper. And according to the documentary, she's never lost a murder case. So he's in pretty hot water. He eventually decides to hire an attorney. I don't know where they got the money from, but eventually he hired a very good attorney who had done some work. I think it might have even been in the OJ trial. He was an attorney that did some legal analysis. And he sits down with the defendant and he says, look, where were you when this happened? It was May of 2004. So I think it was May 12th. So they isolate the day and he says, where were you around that time? And at first the guy didn't remember, but then he says, I was at a Dodger game. He says, all right, let's try to get proof. So his 4-year-old daughter ultimately testifies. She's willing to say they were at the Dodger game, but she's 4 years old. She doesn't know May 4th. Another guy who testified was his friend, who also said that they were at the ball game on May 4th. And I think they even had some ticket stubs. But that's not perfect evidence because the friend could be lying. The daughter could be mistaken. Maybe it was another game they went to at Dodger Stadium. So the attorney contacts the LA Dodgers. And he says, can I look at video footage? They knew where the guy was sitting, so they didn't have to look at footage of the whole stadium, but they wanted to isolate that area and come up with where that guy was sitting, and if they could capture him, that could help provide him with an alibi, depending on the time. He looks through the videos and he sees what looks like the guy from a distance, but it's grainy, and it's not. The prosecutor doesn't accept it because it could be somebody else that looks similar. Again, just like eyewitness testimony, it might not be that guy. It could be somebody that looked like that guy. So the defendant says to his attorney, wait a minute, there was something going on when I was at the ball game, something different, and he had been at a lot of games, than the normal game where you see the camera panning the crowd. He said it was like a documentary or a TV show. So with that, the attorney contacts the LA Dodgers again, and he says, can I come in and see you? Were you filming any kind of documentary or something like that? And the LA Dodger organization, they had a guy who I guess handles those kinds of issues. He says, we let people film here frequently. This is LA. Movies can be made there, TV shows can be made, documentaries, commercials, you name it. So he says, all right, let's go to May 12th and see what was going on that day. And they look in the book and they're going through May, nothing. And then finally, it says HBO. And the attorney says, what was being filmed by HBO on that day? And the official from the Dodger organization says, Curb Your Enthusiasm. Many of you heard of that show by Larry David, who is a co-writer, co-creator of Seinfeld. In fact, he had a cameo in one of the episodes where he was Frank Costanza's attorney and he was the man with the cape. He also, I think, appeared with that cape on almost like Batman, on a ledge or a roof toward the end of the episode. But that's the guy. And the attorney then contacted HBO, Curb Your Enthusiasm, and it says, can we go through your footage? Because that's really the only way to see if you picked this guy up. Because it turns out, by luck, they were in the exact same section. Talk about luck. How big Dodger Stadium? I don't know what the attendance is, 40, 50,000, whatever it is. And of all places, they happen to be in that one section where Juan Catalan happened to be sitting. So they looked through it. At first they found nothing. And then they found some footage that was like an outtake. They didn't use it in the show. Let me go back a little bit. That show was very funny. I didn't see the whole show. I saw bits and pieces. And someone told me about that years ago when I said, oh, I heard of Curb Your Enthusiasm. What's it about? So Larry David is an interesting character. And in that episode, he's driving to a Dodger game in LA. And traffic is murder on the LA freeway. He pulls over. He doesn't think he's going to make the game. And a prostitute walks over to his car. And she says, you want a date? And he says, get in. Not that he wanted to date her, he wanted to use her to get to the game. He could hop in the HOV lane. But once he got to the game, he had to bring her in, buy her food. So that's the whole episode. But at the end of the episode, Larry David, toward some point of the episode, Larry David goes down, he sees a friend who has an open seat, and he says, I want to sit there. And the guy says, no, I don't want you sitting next to me. He's coming back, and he's waving to the crowd, and this doesn't appear to be in the show. He's waving to the crowd. Now, if Juan Catalan hadn't gotten up with his daughter to get some ice cream and then come back at the right moment, you would have never seen him, because where he was sitting, the camera wouldn't have picked him up. The camera was panning down, straight down, toward the field. Larry David is coming up, waving to the crowd, and that's all you see. The narrow swath of the backs of fans and Larry David waving to the crowd, working the crowd up. But right before that, Juan Catalan and his daughter went to get ice cream, and as they were coming back, it's in the documentary, one of the guys crew was supposed to stop people from going down at a couple of minutes. They said they couldn't stop them because they were paying customers, but at the right moment they were saying, you can't go down, we're filming something, just wait a minute or two. The guy got distracted, and Juan Catalan and his daughter went down the aisle toward where Larry David was coming up, and he made a left to where his seats were, him and his daughter. And at that moment, he turned, Juan Catalan, well, he had his daughter's hand, and his daughter went into the seat, and you could see his face. The camera caught his face clearly. So you know he was at the game at that moment and shortly thereafter. So you think that would have been the end of it, but it wasn't. That provided him a good alibi up until a certain time, and I think the game might have gone into extra innings. But he still had a small window to be able to hop in his car, drive over there and shoot the girl. In fact, one of the friends that was with him lived on the same block. So the prosecutor said, well, maybe you were there, you hopped in your car, you sped to the scene, you shot the girl. But fortunately for him, again, so they gave him a good alibi for that period of time, proved that he was at Dodger Stadium. Before he left, he called his girlfriend on his cell phone. That provided pings. So the attorney contacted the phone company, and there were pings that showed where exactly that phone was. Now, if they didn't place him at Dodger Stadium, the prosecutor could have said, well, maybe he gave his phone to a friend, and he was never at Dodger Stadium, and he was lying in wait. The girl came out, he shot her, and the friend made a phone call, because you can't tell who made the phone call, just that phone, cell phone. But because the alibi provided him with a time frame right before the shooting, and then the cell phone put that phone at the shooting, ultimately at a hearing, not even at a trial, but at a pre-trial hearing, the case was dismissed. They interviewed the judge, and the judge said, I even talked to my kids about it. It was almost like a painful decision, because you don't want to get the wrong guy, but you don't want to let the guilty guy go free. And the thing is, if you have an innocent man convicted, not only do you ruin his life, but the people or person that did that are still out there, and it could affect other people. But with that, the case was dismissed. And it's funny, because some people might ask, what do you mean by a pretrial hearing as opposed to a trial? Remember my cousin Vinny, where there was a pretrial hearing and there was some witnesses called, and my cousin Vinny's cousin had a friend, the other guy that got shot, I think his name was something like Lichtenstein or Steen, he kept correcting them, and Rothenstein, something like that. And he said, Vinny, why didn't you ask questions? You knew that you could ask questions. So Vinny said, this is effing Alabama. There's no way the case is not going to trial. Most times you do not win the hearing. There's enough, the bar is low enough where the case would go to trial, and then a trial it's beyond a reasonable doubt. But fortunately for him, the judge accepted the evidence, the alibi, all of that. So Larry David helped this man, or prevented him from going on death row. Now, what's interesting is this man was facing death row based on the eyewitness testimony of one person. There was no DNA. There was no other forensics, fingerprint, blood, semen, nothing. One witness who apparently was running from the scene, because think about it. It was in the evening, so it's dark to begin with. The lighting wasn't great. If you're at, let's say you're standing on a street corner or in a mall, anywhere, and you hear gunshots, your first reaction is not necessarily to look at the gunman. Your reaction would be, like most people, cut and run, jump behind something, get out of the way. Because if you're not armed, even people that are armed, that might be to cut and run. Like the shooting in Florida, where a sheriff's deputy did not go in and engage the shooter, where he could have saved some lives. In fact, the sheriff ultimately, recently was suspended. But here, the witness testified that was him, but again, I'm sure, they didn't show it in this documentary, I'm sure the attorney could have said, you hear gunshots, what are you doing? You're not staring at the shooter saying, oh, you know what, I got that guy now. I know who it is. So that case was ultimately dismissed. There's another interesting case going way back to 1984, and later DNA, which wasn't available at that time to that extent. This man named Kirk Bloodsworth, he was charged with raping and murdering a 9-year-old girl. 5 witnesses put him at the scene as the culprit. He was convicted after trial and sentenced to the gas chamber. I don't know the state it was in, but had the death penalty in '84. 9 years later, he sits in jail for 9 years. I guess the attorney got a hold of some DNA, or they had DNA all along, or they had a sample all along, and with new advancements, the DNA cleared him, he was set free. But here's a man served 9 years. Catalan only was in jail a relatively short period of time. He sued the LAPD and he won $332,000. Now, I talked about that with other people and they said, why didn't he win more? Well, first of all, it was '04, so it wasn't, maybe today somebody would have got a bigger award. You hear $1 million, $2 million. And where you hear the very big awards, like millions of dollars, it's usually because the individual or the defendant served many years, 10 years. Tankleff served 17 and a half years, went in at 17 and a half, came out twice his age of when he went in, 34. People like that serve many, many years. They're more likely to get a lot of money. Bloodsworth, they didn't talk about if he sued and got money, but I suspect he could have. But here, there were 5 witnesses. So think about that for a second. You're a juror, and you hear 5 people, or you see 5 people testify. That's the guy, 5 times. You're more likely to convict than if it's only 1. So in the Bloodworth's case, he was set free because of DNA, and the 5 witnesses turned out to be incorrect. I'm not saying they were lying. They were incorrect. Now, eyewitness testimony is usually based on a number of things. Obviously, a witness sees something, a crime in progress, somebody running from the scene. Now, if they know the person, oh, that's Bob Jones, that's easy. Assuming the person had enough lighting, had decent eyesight, I know Bob Jones, that was the guy running from the scene. That's more believable because he knew who the person was. There was no mistake, generally. So it could be a police lineup. They bring the guy into the precinct and they say, do you see the guy? That's assuming they catch somebody. Or it could be a sketch artist, like they did with Catalan. Or it could be a binder of defendants. I was going to say binder of women, like from one of the last elections, where the guy said a binder of women. A binder of defendants. And I think New York is one of the few places that still does that, where they have somebody, did you see who did it? Yes, I did. Sit down, they do a photo spread or binder of people that have criminal records. That's where they get the pictures from. Do you see him? Yeah, that's the guy. Sometimes it's good, sometimes it's not. There was a well-known study, I want to talk about a well-known study that they did to talk about how unreliable memory can be, things like that, where they spoke to someone's family, a number of subjects, and they came up with 4 stories. 3 actually happened, so they might have talked to the father and said, in Bill's life, what happened when he was younger? Maybe something traumatic. Oh yeah, he was almost kidnapped, or he was in a car accident. So they come up with 4 scenarios. 3 really happened to the guy or woman. 1 didn't. 1 is totally fabricated. They might have taken something like, oh, where did you go with your son when he was younger? Oh, the Smith Haven Mall. Okay, we'll just throw that in there. And we'll say, you were almost abducted at the Smith Haven Mall, or this is what happened. And then they say to the person, do you remember these 4 instances? 33%, a third, believed the 4th made-up instance. So it was totally made up, and yet they talked about it. They filled in the blanks. They said it happened. Even after a subsequent interview, they still said it happened, about a third. That's pretty scary. I'm not talking about, 1 in 100 or something like that. A third. Now, back to memory and eyewitness testimony. They say, the science tells us that eyewitness, or memory I should say, is not like a camcorder. Right now, I'm being taped, and then that'll be shown on Altice Saturday and Thursday. And it'll play back exactly what happened. Memory is not like that. Memory can change. We can fill in blanks. The longer it gets from when we witnessed it, things can change. People can influence us. Like, you ever tell a story and the person says, that didn't happen that way, and you're like, oh, you're right. It didn't happen on a Tuesday, it was a Wednesday, or I was wearing a blue shirt, not a white shirt, or Bill wasn't there. That person's not lying, they're mistaken. Now, if you're mistaken when you tell a story, big deal. When you're mistaken about a murder suspect, to that individual, it's a big deal. And to someone else that might get killed by the right defendant who's still on the streets, that's a big deal. Now, state legislators are coming out with some proposed legislation to make it safer, make it more reliable when we're dealing with eyewitness testimony. Now, these are some of the things that they've been talking about. One is videotape the identification process. Just like they should videotape, and it's very cheap. It's not expensive to do these things. Videotape a confession, because was the person in distress when they were giving their confession? Were the cops riding them? So you better answer the question this way, or you better give us an answer, or you're not going to go to the bathroom, or we'll give you a drink, or if the person is freezing, we'll warm things up a little bit for you. So videotape a confession, videotape the identification process. So a jury can see, okay, that person was clear, that was the person. Because what if the person gets on the stand and says, no doubt in my mind, it was that guy. But meanwhile, in the identification process, let's say it's a lineup. There are 5 people, 6 people in a lineup, and the person who's being videotaped, being told to pick out the defendant, is looking and saying, I'm not sure. And then the cop, let's say, says, take a look at the guy second from the left. That's the guy. The jury should see that, because on the witness stand, the person is 100% sure. They weren't that sure an hour after the crime happened when they got a defendant, they put him in that lineup. So videotape it. Put individuals in the lineup that resemble the witness. If you have a black defendant, you're not going to have the other guys in the lineup all white. That wouldn't be fair to the black defendant, because the person's going to say it was a black guy, then it's got to be him. Inform the viewer that the perpetrator may or may not be in the lineup or in the binder of books, photographs. Right? Let them know so they don't feel pressured. It's got to be one of them, and they may pick the wrong guy. The person administering the lineup or other ID procedure does not know who the subject is. It's very important. I'll tell you why. As I gave the example before, what if the person is not sure? And they're looking at 5 or 6 people. And the cop who knows who it is, and not that he thinks the person, he wants to convict an innocent man, but he's convinced he got the right guy. Subliminally or intentionally, he might say, look at the guy in the middle, or the guy with the green shirt. Take another look at him. And you're sending a message to that person, well, that's the guy. That's wrong. The person who's doing it, get another cop and say, you administer it. He doesn't know. He can't prejudice the person who's picking out someone from the lineup. The next one, I don't think will ever happen, but allow experts regarding ID testimony to testify to educate the jury about these problems I've been talking about for the last 15 or so minutes. So the jury can be educated, just like they're educated about DNA. An expert can get on the stand and say, this is what this means. I don't see that happening. Some judges have ruled it's pretty common sense that it's a flawed process, but you're not going to see, I don't think you're going to see that. Some of the reasons why the wrong person is convicted is because of a mistake, obviously. But there's a thing called the cross-race effect. And humans are notoriously poor at distinguishing between people of different races than their own. There's an expression, they all look alike. I know that might sound racist, but that's an expression that the science tells us is accurate. And what do they tell us? What does the science tell us? If you are a white person, and let's say you didn't grow up with black people, and I'll get to that in a second, how you can minimize the effect, but you grew up in a white community, and you didn't see a lot of blacks, or maybe Asians, or whatever, you're better at picking out a white person than you would a black or Asian. Because they say that we look at a person, and if they're of a different race, we recognize, we know, I'm looking at a black person, I'm looking at a Hispanic, an Asian, whatever. But we don't focus on their looks the same way. Right? We're not as critical as if we look at a white person, we'll know their features better. And there's 2 hypotheses. One is we spend more time with people of our own race and gain perpetual expertise in identification. Right? Like when a baby is born, they have the mother imprinting, or the duck. If you have a dog, the duck might be imprinted to follow the dog as their parent. Well, that's a similar science behind it, where you see white people growing up, you're more likely to say, I can pick those white people out better than a black person. And a black person would pick out a black person better than maybe a white person. And it might even be harder for whites for this reason. If you're a black person, you're in the minority. So you may grow up in a community where you're going to come across white people on TV, movies, you go to the bank. So even if you're in a community that's almost all black, you still come across in contact with white people. Whereas a white person might not come in contact with black people the same way. Right? The second hypothesis is people think categorically about members of other races. I was just talking about that, where you say, that's a black guy, well, that's a Chinese man, well, that's a Hispanic fella, whatever. But the same as a black person might say, that's a white guy. But they might not distinguish the features the same way. And we tend to tune out characteristics which are important in identifying a defendant. So we might get a general look, but that's not good enough. You might say, yeah, it was a black guy, and yeah, that's probably him. That's not good enough. You're not going to convict somebody. That's reasonable doubt on steroids. And what's interesting is the science tells us that prejudiced people and non-prejudiced people fail at the same rates. So if you have an Archie Bunker identifying a black guy and a person that doesn't have a prejudiced bone in his body identifying a black guy, they will fail at the same rates. Now, how to minimize the effect, which is something that you can't always do because we can't go retroactively back. But if infants are regularly see and interact with members of other races, the cross-race effect may not emerge. Pretty amazing. So a white kid grows up in a community that's white, black, green, yellow, Hispanic, Chinese. They're more likely not to even have that effect. Now, based on organizations such as the Innocence Project, they use technology such as DNA to clear people that are wrongly accused. And it's amazing, because years ago, you had fingerprints and you had the blood. So if they found blood at a scene, all they could really say is the person who did it may have had O blood, O positive, negative. That's a lot of people that fall within that category. DNA is different. What really got me with the OJ trial was that they talked about, well, maybe the DNA degraded. Well, now, if DNA degrades, you don't get another person. It degrades, you can't use it. So it wasn't like, oh, the DNA degraded because it wasn't collected properly and it turned into OJ's DNA. No, that's not how it works. Now, very quickly, because we're running out of time, I want to talk about the interplay between Brady material and witness identification. The Brady material is something that I've talked about with my former co-host, Frank Vetro, on FM radio, when we were on 103.9 FM, LA News Radio, and also doing the show on WLANY. Brady material is material the DA has to turn over that could exculpate, prove the defendant innocent, or be used by the defense attorney to cross-examine and impeach eyewitness testimony or other kinds of evidence. Now, unfortunately, not all DAs turn this over. In fact, the Suffolk DA lost his job last year, a Nassau ADA lost her job, and you read about Brady violations all the time. Because if you're an attorney, defense attorney, and this is assuming it's not a big high-profile case, you're not going to know what you don't have. It's like you don't know what you don't know. The DA turns things over and you assume that's it. At a high-profile case like OJ, people are coming out of the woodworks to say, oh, I saw this or I saw that, or that witness said this or that. So very quickly, because we're running out of time, my producer's saying, if you like the show, if you see it on YouTube, like it, share it. What's the other terminology they use? Like, share, subscribe. Okay. So very quickly, so with Brady, so let's say a criminal defendant is charged with a crime. The prosecutor has to turn over everything. Let's say there's a witness let's say it's a black individual that is accused. But at the time of the shooting, a white guy with red hair is seen running from the scene. That has to be turned over to the defense attorney. That doesn't mean the white guy with red hair did it or that the black guy did it. But that's something that's called Brady that could exculpate. So let's say 5 eyewitnesses come forward and say it was the black guy. The defense attorney could say, wait a minute, my defendant is black. However, there's a witness that said that there was a white guy with red hair running from the scene. He could be guilty. That could cause reasonable doubt. So it's very important that eyewitness testimony is taken seriously, and it has an interplay with Brady because information can be turned over that'll give the defense attorney something to build on. So it's not just, maybe the black guy was standing there and the white guy with red hair did the shooting, he's running from the scene, and the black guy's standing around, so what's going on here? I didn't do it. So that's something that could create reasonable doubt. Now we're running out of time, but I want you to stick around for the next 2 segments. They're going to be frequently asked legal questions, and then also Levi Strauss, an exceptional American. He came from Bavaria. He set up shop here. It's an amazing, amazing story because you think about, oh, it's just blue jeans. It was like planes, trains, and automobiles before they had some of those things. And he had to go all the way around through Panama to get to California to start selling his wares. And it wasn't even jeans he started selling at the time. To gold miners. Very interesting story. If you know the San Francisco 49ers, was around that time. That's why they call the 49ers, because of the gold rush. He was there on 48, 49, so he rode the wave. Stick around and watch those two great segments coming up. Thank you. Welcome back. This is segment 2. This is a segment I call Frequently Asked Questions. Often I'm stopped in the hallway and people ask me questions, or people call my office and they say, I have a legal question, or friends ask me. So what I've done through the years is compile these questions, and I answer about 8 or 9 of them with this segment. You can also go to my YouTube page, Jusino Law, and look up Frequently Asked Questions. We just started that, so there's only probably about 4 or 5 on there, but as time goes by, you're going to hear questions answered involving criminal cases, family court, divorce, personal injury, and wills and estates. First question, what do I do if I'm served with an order of protection? There's 2 courts that issue orders of protection. One is family court and one is criminal court. Let's touch on family court for a second. To get an order of protection, someone has to go down to family court, fill out a petition, and it has to be a family member. It could be a boyfriend, girlfriend, it could be somebody you have a kid with, it could be your mother, it could be your spouse. If it's none of those, you'd have to go to criminal court to get the order of protection. So the person gets the order of protection by going before the judge. The judge, it's called ex parte. Right? They don't have anybody else there to rebut it. It's the person making the allegation. They walk into the courtroom. The respondent's not there, not yet, and the judge says, is this petition accurate? Sometimes a judge will say, what happened? Other times they'll say, if this is accurate, I'll give you the order of protection. In other words, it has to have a prima facie case, meaning on its face it's sufficient that there's an Article 8 violation, assault, menacing, harassment, disorderly conduct, something that's an Article 8. So when you get served, the sheriff will walk up to your door or at work and hand it to you. It's going to have the date of the court date. It could be 2 days later, it could be a week later. If it's a stay away, you could be escorted out of your house. If it's a refrain from, no. But you got to be careful because the other person now has a weapon to get you charged with a potential felony. So once you're served, the first thing you should do is get a good attorney that handles these kinds of cases like myself. Because they're going to advise you what your options are. And very simply, your options are to go to court and fight it and say, I didn't do that. Or to go to court and consent to it. You can consent without making an admission that you did anything wrong. And these are things that your attorney will talk to you about. Because if you did do it, then maybe consenting isn't a bad thing to do. If you didn't do it, it's like pleading guilty to something you didn't do. You might not want to do that. And there are consequences. If it's somebody you're never going to see again, you might not want to fight as hard. If it's a spouse and you have kids in common, you want to make sure that there's not something that she's going to be able to use to get you arrested again or get you arrested. In a criminal case, the order of protection is issued by a judge, like in family court, but it involves a criminal charge or a violation, where in family court there's no underlying criminal charge. So it's just the order of protection. In a criminal case, you could be charged with assault, menacing, rape, you name it. And a person can go to a judge, or the DA can ask on behalf of the complaining witness, and then there's an order of protection. Again, when you get served, get a good attorney. Because, especially in a criminal case, you need to. If you have a criminal charge, you can't go in there without an attorney, because they're going to say, come back with an attorney. Even a violation, because there are consequences. You might think, it's just a violation, no big deal. If you admit to it or plead guilty to something in criminal court, that order of protection could be 1 year, 2 years, 5 years, even 10 years in certain types of cases. So you got to be careful. Next question, do grandparents have visitation rights? I handle a lot of those. The answer is yes, they do. Or is it the same rights as, let's say, a husband or a wife or people that have a kid in common? No, it's not the same, but they have rights. You would have to establish that there's been contact or your contact has been frustrated. So if you're a grandparent and let's say your grandkid is 10 years old, you've never been in the kid's life, not because you weren't allowed, you just weren't around, and then you say, you know what, I want to have visitation with my grandson. Chances are you're not going to get it unless the other side agrees. And there are some things that you have to factor in. If it's a set of grandparents whose child is one of the parents has died, they have an automatic right to petition a court. They have a clearer path to getting visitation, as opposed to if their son is still alive and the son is saying, I don't want my parents visiting. Right? They can still get it, but it's going to be a little bit harder. The same thing. Get an attorney who handles these cases on a regular basis. They can tell you what you need to prove and what you're entitled to. Sometimes people think, oh, I want alternate weekends as a grandparent. You're not going to get that in all likelihood. Next question. What do I do if I'm served with a neglect petition? Now, a neglect petition is for an abuse or neglect case involving a child or children, and that happens in family court, not in criminal court. There could be a criminal component to it, but a neglect petition brings you into family court. CPS might be involved. If it's involving the neglect of a kid, CPS could very well be involved. When you get served with a neglect petition, again, get a good attorney that is in family court all the time. You might get a great criminal attorney, but if they don't know their way around family court, it's not going to help you too much. All right? The neglect petition would allege you did something to one or more children. Again, it could be abuse where you beat them. It could be neglect where you didn't send them to school, or you starved them, or you didn't give them proper medical attention. Those things will be adjudicated in family court. And it could be one of the parties or both parents. It could be one set of parents. It could be one parent where the other parent didn't do anything wrong and it's only against one, or it could be against both parents. Just like if the parents are on drugs or one of them is an alcoholic, that could affect where that child ends up. Because if a petition is served on you, even as you get to court, they can take that child from you. Now, you're going to get your day in court, due process, but the court can say, until you get into a drug program, or until you get into an alcohol program, or until you take care of some issue, you're not getting your kids back. Or I have a number of cases where, let's say, only one party has the issue. Well, that party can't be alone with that child. So they can live at home, but they can't be left alone. So when the husband is home, let's say it's the wife, it's okay, she can be there. Or when he goes to work, some other family member or friend would have to come that's approved and, in a sense, supervise. Next question. What is an arraignment? An arraignment is the first appearance in criminal court where the person, the criminal defendant, or through their attorney, enters a plea of not guilty. Even if they want to plead guilty, 99.9% of the time, even all the time, pretty much, the judge will say, I'm not going to take a guilty plea at this stage of the game. Enter a plea of not guilty. That is the first thing that happens at an arraignment. The next thing is the judge going to impose bail. So if the person was arrested and was in custody, brought before the judge, they do an ROR score, 0 to 11. That person is a high risk to leave the jurisdiction or is not a risk at all. Then the judge might say, not a risk, all right, you can go. Just come back on the next court date. Or if you score a 3 and the person's from a different state or even a different country, they might say bail is $1,000, $5,000, $100,000. What if the person can't make that bail? They may have to go to a bail bondsman. Because they have the cash, they can just post it. If they don't have it, they have to put up an asset. Could be a car, could be a house, could be some other significant asset where the bail bondsman knows that, okay, if this guy skips town, at least I'll be compensated. Of course, what will happen is they'll have to make good on that bond. Next question. Can I get time to pay fines? The answer is generally yes, but it depends on the court. Suffolk County, they usually give you up to 3 months. If you need more time, you can get more. Nassau District Court, they tend to say you got to have the fine money. So if you don't have it, you may have to pay your attorney to come back another time when you do have it. It's like a double whammy because you didn't have the money in the first place. Now you got to get the money for the fine and the money for the attorney. But here in Suffolk County, the court will give you time to pay the fine generally. Nassau, not so much. What if I can't afford an attorney? A couple of things can happen. They can appoint a law guardian. They can appoint what they call legal aid. That's an attorney that is paid by a panel, and if you qualify, in other words, if you're making $100,000 a year, you're not getting legal aid. if you make under a certain amount, and let's say you have a bunch of dependents, you may qualify. So you go for an intake, and then they say, okay, you qualify, you go to the courtroom, you're going to have an attorney there. It might not be the same attorney every time, but you'll be assigned an attorney. What if there's a co-defendant? And let's say you have two guys that don't have a lot of money, they can't both get legal aid, because that would be a conflict of interest. It would be like having two attorneys from the same law firm. So one might get legal aid, one would get what they call 18B, or if it's a murder case, 18A. It's appointed from a panel. These are private attorneys. I was one for a number of years. 18B, law guardian panel. They are private attorneys that are there for like conflicts of interest, things like that. Next question. What do I do if I'm injured in an accident? So let's say you're driving down the street and you get into a car accident and it's not your fault. And you're injured, you have an injury. Contact an attorney who handles personal injury matters. That attorney will first want to check out two things. Who's at fault? If you say, oh, I hit a tree, you're not going to, you have no fault, your bills will be paid, but you're not going to get a sum of money because it was your fault. If someone else was at fault, that's the first step. Okay, who's at fault? The other side? Okay. The next one is, were you actually injured? I've had people call me all the time and say, yes, some guy broadsided me. Are you hurt? Well, my neck's a little stiff, but I'm not going to take a case like that, because the attorney gets paid a third, generally a third, plus expenses of the total settlement. If there's no injury, the case probably won't survive a motion, where the defense attorney can make a motion saying there's no injury. Just like in an assault case, in a criminal case, you have to have a serious physical injury. Well, you need an injury in a personal injury case. It used to be easier to collect on soft tissue, but not anymore. I think we have time for one more question. What happens if I die without a will? The laws of intestacy kick in, and it says where your property is going to go. So I'll give you an example. Let's say you have 3 kids and you want to leave a will, and you want to just give it to one of the kids or 2 of the kids, but not all kids. You can do that. You don't have to leave any property to your kids. So you say, I leave it to Bill and Frank, but I don't want it to go to Tom. You can do that. If you die without a will, all 3 kids will equally receive your estate, because they're the next class down. If you have no kids, then it can go to a parent or a sibling, like that. So if you want to dictate where your property is going to go, make a will. All right. I think we have time for one more, Dan. What is a life estate? Very simply, let's say you own a piece of property, and when you die, you want it to go to someone, but you don't want them to have to do a probate, let's say. And you don't want Social Security coming after you, the government, to get your money to say, wait a minute, you're going into a facility, you have a house, we're going after that house. You want to protect it as a look back of 7 years. You can give the property to, let's say, one of your kids, or both of your kids, or all of your kids, and retain a life estate, meaning you can live in that house until you choose to leave or until you die. Now, obviously, the mortgage would have to be paid and taxes, but you have a life estate. You don't own it, but you have an ownership interest in that property. So we're out of time. The questions I have left we'll go over next week. Stick around for segment 3, American Exceptionalism, Levi Strauss. Be right back. This is segment 3, American Exceptionalism. Levi Strauss is the topic for this segment. Now, everybody watching has probably worn dungarees, Levi's at one time. So you say, what's the big deal? It's a pair of pants. It is an amazing, amazing story. We marvel at Tesla and Edison and Gates. Listen to this man's story. This is a rags to riches. He came in from another country, and when he died, he left an estate worth $3.5 billion in today's dollars. Right? Actually, the amount was $125 million, but in today's dollars, $3.5 billion. Here was a man that was born in Bavaria, in the German Confederation, and in 1829, came to America with his sisters and his mother to be with the 2 older brothers who had started a dry goods business. came to America at 18, joined his brothers, and they were already in business. At 18 years old, he wanted to be an American very badly. He taught himself English. He didn't come here learning English or having learned English. And he became an American citizen in 1853, 24 years old. Once he became an American citizen, he wanted to set out and make his fortune. His family decided that they wanted to sell their goods on the West Coast in San Francisco. Now don't forget, in 1849, gold was discovered in 1848, Sutter's Mill. In 1849, they had the California Gold Rush. That's why the 49ers are named the 49ers from San Francisco. So with that, he was chosen to go to San Francisco. And back then, it wasn't that easy to do. It wasn't like you hop on a plane, business class, and you're there in 5.5 hours. He chose the quickest path. And he went by himself. And he had all his goods with him because he had to bring it out to California. He chose going the passageway. It was called the Isthmus of Panama. Now, this is before the Panama Canal, which came out in 1904. So he had to endure a lot of hardships just to make it to California. It took him 13 months. Right? If you drive, you can get there maybe 5 days in a car with air conditioning and a radio. He took 13 months to get to San Francisco. First, he had to go by steamship that got him down around California to where he needed to go to the next leg of his journey. It's like Florida, down toward Florida. Then what he did was he had to take the Panama Railway, and he took that until the tracks ended. Then he had to canoe upriver, again, with all his goods, in a canoe. Then he had to ride mules for 20 miles to get him to the Pacific Ocean. Once he got there, he took a ship up to San Francisco, and he started out in business. Now, there's a myth that he started out selling pants. He didn't. He had dry goods and materials, canvas for tents and things like that. He didn't sell pants for a little while. And it's very fascinating how it came to be that he sold pants. Now, during his journey, he had to endure sweltering heat. He would sleep in bug-infested tents, torrential rains. Not pleasant. But he and his wares got to California, San Francisco. Now, once he got there, his brothers also had shipped overland more goods to him. So he was able to go to the camps, the gold camps, the gold miners' camps, to peddle his wares. And his brothers shipped the goods, and his business grew. In fact, it grew so big that in a relatively short period of time, he had to move 4 times. And then what happened next is pretty amazing. There was a tailor named Jacob Davis, and he bought the goods, and he said, these would make good overalls to go over people's pants. Not even as the jeans as we know them, but more overalls, almost like chaps. Like you see the cowboys with the leather chaps. These were to go over their clothes to protect them because the gold miners were in the dirt, in the ground, and their pants would wear out. So he made the pants, and they were very durable. The problem was they would rip, and some gold miners lost gold. It fell out of their pockets. So what he did was he came up with these rivets. You see the rivets on the jeans? That existed from way back when the tailor, Jacob Davis, came up with it. And the rivets would keep the pockets intact. So he approached Levi Strauss and he said, let's get a patent together. Because he knew the material wasn't his. He was using the material to make the jeans, or the overalls. Weren't called jeans yet. So they applied for the patent together, and then they went into business, Davis and Strauss, making these jeans. And at first they were called waist overalls. And this patent was granted on May 20th, 1873. So they started selling a lot of these. In fact, they sold over 20 pairs of these pants within 1 year. Pretty amazing. And soon everyone was calling them Levi's because of Levi Strauss. So these pants that he didn't even invent but it was his material. With the help of a tailor, they teamed up, and these pants were selling like hotcakes. And his business grew, and he became a pillar of the community. And he gave back to the community. Now, he was born in Bavaria to a Jewish family. But here in America, he gave to Jewish causes as well as Christian causes. And he was a very well-respected man in the community. He never married or had any children. And when he died at 73, and he worked every day up until the day he died. And it was pretty amazing. He has a quote, and I think it applies to a lot of people. I think it applies to me. He said, "I don't believe that a man who forms the habit of being busy can retire and be contented." He wasn't the kind of guy that was going to retire and play golf. He worked his whole life. He gave a lot of money to the community. And he brought his nephews into the business, because as the business grew, his in-laws also started to be part of the business. So he brought the whole family in. And his brothers had stayed in New York doing what they were doing with the dry good business, and he was their California contact. Now, he ended up leaving the company to his 4 nephews. And his estate was worth, when he died at the age of 73, $125 million. In today's dollars, and I said this earlier, would be worth $3.5 billion. Think about that for a second. $3.5 billion. That money could almost build the wall. Little joke. But what he did was certainly what a person dreams of. Coming to America, getting here, getting acclimated to the environment, the melting pot, becoming part of the fabric of America. He became an American. That's what he wanted. And he grew his business with his family. He took the risks. That's big. He took risks to get to California. He could have died along the way. He could have been robbed. He had a lot of dry goods with him. Somebody could have picked him off, taken his dry goods, and left him for dead. That didn't happen. He took the risks. That's what people in business do. Even Tesla, Edison, right? They risk a lot of their time, their good name, their whatever fortunes they've made along the way. And here's a guy that came to America with very little, and he ended up his life a multi-millionaire. That is the American dream. That is why I am a capitalist on steroids. Not a socialist, capitalist. Because America benefits from people like him. He could have come here. He wasn't given welfare. He wasn't given food stamps. He had to make it on his own. They didn't have the safety net that they have nowadays for people that are, let's say, injured or disabled or have fallen on hard times. We need a safety net for people like that. But this guy risked it all, and he made a fortune. And he kept that fortune, and he ended up giving it upon his death to his family. And the name continued. You can go to the store right now and buy Levi Strauss jeans. Right? And earlier today, it was funny, I was on social media, and there was some debates going back about socialism and skilled labor and unskilled labor. And I made a comment, and I wanted to say it again. And I said that monies that are put directly into the economy, it's better than money going to the government. Obviously, the government needs money. We need a military. We need a judiciary. There are things we need. There are things we don't need. But the government is like a black hole. They take your money and they waste a lot of it. But with a capitalist, they want to put money into their pockets, but they're also putting money into the economy. So people might say, oh, he's a selfish capitalist. He's not being selfish. Right? He wants to earn money for himself and his family. But he's also putting money into the economy. And the comment I made was this. I said, a little kid with a lemonade stand is a better and more efficient economic engine than the government. I came up with that by myself. What I meant is this. That little kid has to make the lemonade, or his mother helps him. And either he gets the lemons that he buys at the store, or he gets the powder, he's buying it at the store. He's buying it from somebody, unless he grew them in his backyard. And then he sits out there for a while. He may make $0. He may make $5. He may make $10. He's satisfying a need. Maybe someone's jogging, they're thirsty, they stop by and they buy lemonade. He's satisfying a need, quenching somebody's thirst. Then he takes that money and he either invests it, or he runs to the store like a lot of little kids do. I remember when I was a kid, you get money and you're like, oh, I want to go buy something. And he runs to the store and he buys something to eat, or he buys his favorite video game. He's putting money back into the government just about dollar for dollar. So if he earns $10 and he goes buys a video game, that money is being, in a sense, recycled back into the economy. People benefit from that. John F. Kennedy gave a very well-received speech many years ago, and in the 60s, and he said, with lower taxes, people have more money. And then Reagan said the same kind of thing, that they have more money in their pocket that goes into the economy. And the money that goes into the economy creates jobs, creates salaries for people. And the more people that are working and the more money they're receiving in salaries, they then spend that money. So that's how an economy grows. When you give the money to the government, let's say you gave $1 million to the government. Let's say you were a rich guy and you said, you know what, I want to help the government out. I'm going to give them $1 million. Do you think $1 million would then go into the economy? It wouldn't. That money would be watered down in some way. Some bureaucrat would find out a way to say, you know what, let's get lavish this, so let's do that. That's not the way an economy grows. So I started out with American exceptionalism, Levi Strauss. He was a capitalist, rags to riches. He came to America, became an American citizen, became a success, and we all benefit from that. I wore Levi's as a kid. He created something, just like Tesla did, just like Edison. So the lesson here is there are many, many exceptional Americans. Some of them don't start out here in America. Some of them come from other countries, and through legal immigration, they come here and they make this country better. Just like a scientist, just like Albert Einstein. He wasn't from here, he came here. And his efforts helped us win the war. So keep that in mind when you think about exceptional people like Abraham Lincoln and George Washington. Levi Strauss, a guy you probably didn't give much thought to. He was an exceptional American, and I rank him pretty high up in entrepreneurs in this country. So I want to thank you for watching. If you missed any of the show, you can catch it on YouTube by going to WLINY Internet Radio. You can watch the shows. It's cataloged. You can watch the Friday shows. You can watch the Altice shows. You can go to Jusino Law, watch Frequently Asked Questions, just like we did the second segment here, Frequently Asked Questions. Like and share and subscribe so you can keep up to date with new shows that are coming out. I really want to thank you for joining us during this show, and catch us again. You take care.